in his pleadings fraud, malicious conduct, or I think the syllabus point says, or other outrageous conduct. Did he allege that in his complaint? And if so, how are you entitled to qualified immunity? I know there wouldn't be insurance, but how do you get qualified immunity?
Notwithstanding the insurance issue, Your Honor, Hutchinson versus City of Huntington and AB both talk about the heightened pleading standard. And just alleging something in these type of cases is not enough. It's important that you not only allege something, that you state what the factors are in it and what are the allegations or facts that support that. In this case, there's a broad, catchphrase terms used, but there's nothing pled. There's nothing in the responsive pleading in this motion.
Is the word fraud alleged?
It's my belief that the words malice, fraud is alleged, Your Honor, but there are no facts or nothing in the pleadings, in the responsive pleadings in this motion.
So you're saying under Hutchinson versus City of Huntington that they have to allege facts to support an allegation of fraud, malicious conduct, or other outrageous conduct?
I believe, and we believe, that the heightened pleading standards set out in Saucier, Katz, Harlow, and adopted by this Court clearly states that. And if you don't meet that standard, then you can't argue in front of this Court. It fails in qualified immunity
Should
attached.
we adopt the federal doctrine of Twombly?
Excuse me, Your Honor?
Should we adopt the federal doctrine of Twombly regarding what must be pled by a plaintiff in order to withstand 12b-6?
I believe the Court, I believe you should, Your Honor. But I believe just the standard enough that's set forth in Saucier, Katz, and Harlow and adopted by this Court in Hutchinson is enough. I think it gives a roadmap as to what the respondents in this case have to do to move forward with those claims.
Okay, but let me ask you one other very quick question. You're saying here that in your response to their complaint, you did specifically raise qualified immunity, not just generic immunity.
That is correct, Your Honor.
All right. Now, my last question. I've actually got a question. The judge's order decided it on sovereign immunity.
The issue of sovereign immunity was brought up, Your Honor. The Clark v. Dunn in the cases.
All I'm asking is,
yes,
the judge decided in his order on sovereign immunity and not qualified immunity.
Your Honor, we do not know what the judge decided because there was no conversation during the hearing itself.
What does his order?
The order says that it was based upon sovereign immunity.
Not qualified.
Yes.
So you contend he erred for not addressing qualified immunity.
He found, in my recollection, is that the words sovereign immunity and immunity, qualified immunity, are both brought up, and they are mentioned. The problem is that the finding in the case.
You just said it wasn't.
In the order?
In the order. In the order. In the argument, it was discussed, and it was part, and it was part of our brief or our order that we submitted.
Well, back to my question. Are you saying it's error, since you raised it, for the judge decided on sovereign immunity rather than addressing qualified immunity?
Sovereign immunity is not the issue that we were arguing at the hearing. Sovereign immunity is not here today.
So your answer is yes?
Yes, yes.
But sovereign immunity is here today because that's what's in the order. It's before us.
And we understand that, the insurance.
The Court speaks to its order.
The insurance provisions, we understand how they apply, and we argued, we asked the Court to certify this question.
But our problem is we weren't there for that argument. How do we decide, just based on representations, we don't have the order to look at? That's the concern I have here.
And I understand, Your Honor, and I would ask that this Court understands the argument as we're trying to set forth, is that if the Court does not find that qualified immunity applies and that this case should be dismissed, that it submits it back to the Circuit Court and asks them to enter an order that states what was actually argued at the hearing so that you can decide that issue. I think the
Your proposed order address qualified immunity?
Yes, Your Honor. And
did he rule from the bench? Did he articulate his opinion and then follow it up with an order, or did he just have you submit orders?
Unfortunately not, Your Honor. Orders were submitted. There was no discussion from the bench, and there hasn't been any of the arguments we've had on this case, other than denying the motion, and that was it. Lastly, I'll say that we believe that Moore v. Strickland, Ortiza v. Mongener, Williams v. Brown addresses the issue as far as an at-will employee, as far as, what they have. There's no property interests in those cases. And also, This court, as well as the United States Supreme Court, has held in many instances that under an at-will employee situation, an appointee can be terminated for any reason, a bad reason, any reason as long as it's not illegal, such as for race, nationality, gender, or age.
Have there been any cases since Hutchison that have addressed the heightened pleading standard?
I believe that the heightened pleading standard is discussed in AB, I believe, Your Honor.
In which case?
In Regional Jail Authority versus AB.
Okay.
I believe it is, but I know it's in Hutchison. Hutchison, this court adopted the standards that are set forth in the United States Supreme Court cases, Associated Katz and Harlow. Thank you.
No, you're done. All right, the case will be submitted.
Next case for argument, Richard Lee Pauley versus West Virginia Bureau for Child Support Enforcement and Connie Jean Walker, 140933. Rising from
Good morning, Your Honors. My name is Richard Pauley.
Wait until the chief gets here.
Oh, sorry.
That's okay. Proceed.
Put these on so I can see. My name is Richard Pauley. And before I begin, I'd like to thank this court for allowing me to be here today to argue my side of this thing. And I'd like to begin by, now in 1978, I was divorced and I had to pay $160 a month child support or until further order of the court. Then I moved to Fairmont, West Virginia and for work, and then ended up living there for a while. And in 1979, I was summoned again for another hearing, and it was in Marion County. It originated by the Kanawha County DHHR before BCSC. They and Connie Walker were the petitioners. I was a respondent. I was pro se. Ms. Walker was there through representation. In the 79 order, it states that both sides gave evidence. After considering the evidence, I was ordered to pay $50 a month. No one objected. It was ordered and signed by the then standing circuit court judge, Meredith. As ordered, I paid my $50 a month. It was accepted for years.
That was towards the back judgment? The 50 was towards the back judgment?
No.
Or just ongoing?
It was well, be truthful, I don't know. It was, as far as I know, as far as I can understand, that it was just, I was to pay $50 a month.
Well, how much have you paid over all these years in child support?
Well,
Let's just find out. How much have you paid?
How much have I paid?
How much do you claim you've paid?
Well, I'm not real sure about how much I paid. I can tell you that it's in that right there in the brief.
I just want to see how much you admit that you've paid or admit that you haven't paid. Well,
The thing is that, now it was a year between the time that, I understand what you're saying, and I'm not real sure how to answer that because I did pay for years. I paid this $50 for years. That's the whole point. And nobody objected. And I never heard anything for the next 26 years. So, as far as I was concerned, this 79 order stood. Mm-hmm. Even if I would have paid this off, I would still be here today because they're using a 78 order, my original 78 order, for a judgment in which they read in, hang on, let me keep with me here. A quarter of a century later, that's when this hearing took place. Now, the 79 order was, by all rights, the place here. The 79 order also complied with the 78 order, and it's still on record at the Marion County Circuit Clerk's office. And it's still the law of case today. It was AR 270-271, voiding the 78 order. So now they said I was served for this 2005 judgment, but I never got nothing from nobody. As far as I know, it was an improper service. AR 292 shows that that was my correct address. I moved up here to fight this thing. They said it come back unclaimed and said in court that that would prove that I lived there, that was like that had some standing. Well, however, they have the burden to prove.
Well, that was your last known address that they mailed it to, was it not? Was that not your last known address?
That was my last known. I lived there for over 10 years.
Okay. And is that not in compliance with West Virginia law?
Well, Your Honor, all I know is that it was in Florida. The sheriff's office will help. They said they sent 2 letters. Now, I don't know if that was at the same time or what the deal was, because he wasn't never specific about it. And they never did prove that.
How much money do you think you owe?
What I wanted to know in the beginning. And
Oh, okay. I get that now.
Well, you should know that. I mean, if you moved all the way up here and you're fighting this, and this is your thing in life that you're going with, well, how much? What's the number?
The 79 order was.
How much do you owe today?
I have overpaid the 79 order by over $2,450.
So you're saying you owe nothing?
I owe nothing.
And this
Although I did try to pay this 3 times actually. The first time they knew before this ever took place. Well, before I ever really went to court, I went to them and we said, listen, there's a 79 order. I got a lawyer, and I went and he went to BCSC and said, well, supposedly this 79 order is a case of law. So then he said, well, how much would you do an audit on it and see how much we owe so we can pay it off? I wanted to pay it off cash, boom, be done with it and go back home. Well, that didn't happen. Instead, they handed him this 2005 judgment and said, well, you owe $2,446 and some odd cents. Right there it is, $42,445.86. However, and then they started saying that this 78 order was the case of law. Well, it's not. The 79 order is the case of law. So they used a 78 order to get a judgment when, in fact, the 79 order was in play. And
so
this is where
you really feel that it was. I really got to just look at this. You feel that $25 a month per kid through all these years was adequate for you to be paying, and it's all you were required to pay in child support for 2 children.
Your Honor, back when this was going on, you got to remember, this is like, my son is 40 years old now.
Yeah.
Okay,
Somebody raised him. Somebody raised him and had to feed him and clothe him and buy his tennis shoes and all that. You realize that?
Excuse me?
Someone had to raise that boy as well as the other child.
Exactly.
Feed him and clothe him, buy his shoes.
Exactly. I
Okay.
get that. Yes, ma'am.
And
You're absolutely right.
You think your $25 a month per child was adequate to do that, and you shouldn't be asked to pay the original order, which was validly entered, and I believe it was $160, a big old $160
Exactly.
for 2 kids.
Exactly.
Okay. Well, what do you do for a living, or what have you done for a living in your life?
Well, back in 1978, I was only 20, uneducated. I was unemployable. So, yes, I had jobs, and they didn't last long. I changed jobs like shirts. Well, so I had to move out of here because every time I turned around, I was going to jail for child support. I couldn't hold a job. Every time I go get a job, they would come and get me and take me to jail for child
Hey, your
support.
child support, that wouldn't happen.
Well, Your Honor, I don't see it that way.
I
I think,
understand
well,
you
I
don't.
should have been given a chance, and I don't mean to be any disrespect to you or anybody else, and I apologize if it sounds that way. I'm really not. What I'm trying to say is, this is 2015. Okay, they came after me with the wrong judge, with a 2005 judgment, with a 78 order, not a 79 order. Okay, the 79 order is the one regardless, that's what I owed. That was my contract between the state of West Virginia and me. That was what I was bound to. Well, so anyway, I'm back. I was in Ohio working. I was out of town. So I got a wage withholding for $23 and something. So I went to the job and I asked them where it came from, and they told me Kanawha County, West Virginia. In 1997, I had a motorcycle wreck where I had brain damage. And for about 4 months after that, I didn't even know who the president was. So I'm not going to say that I forgot about this. However, because my recall is that once something hits that I can remember, yeah, it's like being here has been a nightmare. But the point being is that after I found out about this, I come to check it out. I come to find out what it is and take care of it. It's not like that I really did run. I paid off 2 children in Florida. So I haven't run. And when they told me that I owed $2,000...
Were delinquent on 2 other children in Florida? Payments?
Yes, sir.
Is that what you're saying?
Yes.
Okay.
I did. And now, yeah, I should have been a little more responsible and paid that off in the 79 order off. But regardless, I would still be here today because they're using a 78 order.
Well, I think we understand what you're arguing to us, so let's hear from the other side. Then you'll have another chance to come back and refute anything that they say.
May it please the court, I'm Jonathan Burton, and this is Deanne Burdett. We're from the West Virginia Bureau of Child Support Enforcement, and also this is Mrs. Walker, formerly Miss Spaulding, who's also present. I just wanted to let that...
That's who?
That is Mrs. Walker, the other party in the case. I just wanted to let you all know that she was present today.
Is she an attorney?
She's not an attorney. She is...
Go ahead.
Okay. She is the caretaker in the case. She was
Well, the next time you come to the Supreme Court, only counsel sit at counsel table.
I didn't
That's
see her
not
come
your
up.
fault. You didn't know, so.
Sorry.
Didn't know.
Yeah. So go ahead.
But really, after a long morning, I'd like to try to make probably the shortest argument of the day this afternoon. Our main point is all of this is sort of covered by the doctrine of res judicata.
Well, what about that 79 order he keeps talking about?
79 order. What happened there was a 1978 order in Kanawha County, what would be the equivalent of family court today, and there was we found out much later. We didn't find out until 2009 that there was this order in Marion County, and this is after several appearances in court to discuss this matter, where this 79 order was never brought up.
Now, wait a minute. Just slow down, because I'm not getting everything you're saying. Maybe go closer to the mic. But
Okay.
Are you saying that the case was transferred to Marion County, and this lady, the mother, didn't know that it was transferred?
Apparently, at that time, this is before the Bureau of Child Support Enforcement existed.
Right.
And the Department of Health and Human Services issued a USI to sort of handle a judgment for someone that was in a county other than where they were when the judgment was first handed down. So Mr. Polly was in Marion County, I believe I'm representing that correctly, and there was a hearing held in Marion County, and the child support was lowered to $50 a month.
Now, why was it transferred from Kanawha to Marion?
That was honestly, I don't remember. There was a change in circumstances. I believe there was a change in circumstances with Mr. Polly, but I know it's in the record, but to be honest with you, I don't recall, and I don't want to try to make something.
Well, why doesn't the statute of limitations apply?
When the first case was brought up in when the case was brought up in 2005, we believe that statutes of limitations is an affirmative, at that time, statutes of limitations is an affirmative defense. That was before the Hedrick case, excuse me, and just there was no affirmative defense, of statutes of limitations brought forward at that time. We believe that Mr. Pauley was properly served because we served him with certified mail that was returned, but also with the first-class mail that was not returned.
Well, why doesn't I still don't understand, why doesn't the statute of limitations apply? It doesn't have anything to do with service.
Well, no one brought in affirmative defense of statutes of limitations.
Wait, is there a statute of limitations on child support collection? What is it?
There could be a 10-year. 10 years.
10 years. But how long ago did this action get initiated?
It would be whenever there is a last payment, or unless you get a writ to continue the.
Well, how much has he paid? When was his last payment?
He has paid. He's correct in that he has paid $11,644.66.
Total.
I believe that's what.
$11,644.66.
That's correct.
And how old were the children when the divorce occurred?
And that. Excuse me?
How old were the two children, the dependent children, when the divorce occurred?
When the divorce occurred, I believe they were 5 and 7.
Okay. So for all their growing up years, for two children, he's paid a total of $11,644.66. And how much is it you all claim that he owes?
In the last judgment in circuit court, which was in 2013, we obtained a judgment from our accountings, including interest, because the $11,000 and such, that doesn't include any interest, would be $47,462.63.
And he's paying it, or he's being required to pay it, $150 a month?
That's correct, Your Honor.
Does that, with interest and so on, accruing, does that ever pay off that amount?
The interest has stopped at this point, so that's just going to pay off because the children are